Assalamu alaikum for all the audience and panelists. Welcome to the forum. First of all, I would like to introduce our panelists for today. Our first panel, Ms. Aina Azmiza, and the second panel is Mr. Ahmad Sulehi. Both of our panels are lecturers from Islamic Science University of Malaysia, which is USIM. Thank you for joining our forum this morning. I am Shafatul Husna and I'll be moderating our conversation today about the freedom of assembly in Malaysia. Malaysia's political system has been referred to as a pseudo-democracy, which describes as a political system which calls itself democratic but offers no real choice for the citizens. Although democratic processes and elections and civil participation do exist, the strong state is kept in power by authoritarian laws and underlying systems of patronage and nepotism. Freedom of peaceful assembly in general sometimes used interchangeably with the freedom of association. It is the individual right or ability of people to come together and collectively oppress, pursue, promote, and defend their collective or shared ideas. Freedom of assembly ensures people can gather and meet both publicly and privately. Assemblies can be platforms to advocate for change and for people to raise awareness about the issues that matter to them, whether it is human rights, socio-economic rights, or any other issue. The term freedom of assembly itself often used in the context of labor rights. So, for further detail about this topic, I would like to seek an information and explanation from the first panel, which is Ms. Aina Azmiza. So, Ms. Aina Azmiza, regarding to the freedom of assembly in Malaysia, do we have any laws that govern on that matter?
Thank you for the question, Moderator Shafatul. Regarding the question given, yes, we do have laws that govern the freedom of assembly. Under Federal Constitution, the vital part relating to freedom of assembly is Article 10, Clause 1, Paragraph 3, which states that all citizens have the right to assemble peaceably and without arms. This means that the Federation allows the citizen to assemble, but it must be done in peace and without any weapons. But if it endangers the security of the Federation, it must be restricted, as illustrated under Article 10, Clause 2, Paragraph B. It is also mentioned under Article 1.9 of the Federal Constitution that the Federation gives power to the Parliament to pass special laws to stop or prevent any actual or threatened action by a large body of persons which Parliament believes to be prejudicial to public order, promoting hostility between races, causing disaffection against the state, causing citizens to fear, organize violence against them or their property, or prejudicial to the functioning of any public service or supplies. This means that if the Parliament deems that such assembly may cause harm or promote hostility, Parliament may pass a law to prohibit such assembly. From these articles in Federal Constitution, we can see that the law gives freedom for the citizens to assemble, but there are limitations to it. It is mandatory for us to practice full assembly.
Instead of Federal Constitution, do we have any other laws relating to the freedom of assembly?
Yes, we do. We also have the Police Act 1967 that listed some rules and regulation for the liberty of assembly. According to Section 26 of the Police Act, in an assembly, if the police deems that there must be barriers to be put in order to prevent any mishaps, according to their police point of view, they are allowed to do so. So, let's say there's an assembly going on. If the police thinks that there must be barriers surrounding the assembly to ensure the public safety, they can do so. Besides, we also have Section 27, Subsection 1 of the Police Act, which mention police officer in charge may direct in such manner as he may deem fit the conduct in public places in all assemblies or meetings, whether of persons or of their vehicles, and may prescribe the route by the time at which such assembly may be held. This means that the police are given the right to conduct how the assemblies should be conducted. Okay, under Section 27, Subsection 2, it is also stated that any assemblies must require license from the police, which must be applied 14 days in advance before the assembly is held. Only if the police officer finds that the assembly is free from any disturbance, he may give license. There are other requirements that should be fulfilled to get the license, such as the application for the license shall be made by an organization or jointly by 3 individuals. The police officer to whom the application is made shall refuse the application if he is satisfied that the assembly for which a license is applied is intended to be formed by an organization. Okay. The police officer issuing the license shall specify in the license the names of those persons as licenses. No license shall be on the application of an organization which is not registered under any law in force in Malaysia. Other than the authority on giving the license, okay, the Police Act also gives power to the police officers under section 27 subsection 3, where police officers may stop any assembly which its license has not been issued, or the license was subsequently cancelled because of the unregistered organization, or which contravenes any of the condition of issuing the license, and police may order such assembly to disperse, to stop. Under this Police Act, it also shows an example of an unlawful assembly, where section 27 subsection 5 states that it is unlawful assembly if it's an assembly without license, or if 3 or more persons taking part neglect or refuse to obey police orders. There's a case which is Murugan Anak Lelaki Mugyandi against public prosecutor. The appellant was charged with an offence under this section for being in unlawful assembly, which there's no license has been issued. An application for a license, of course, had been made. It had been made to hold an assembly in front of the British High Commission, but the police in charge had refused the issue of the license. Okay, however, a group of about 600 Indians had headed towards the British High Commission to hold an assembly. The group had failed to disperse despite warnings from the police. In the end, the appellant was convicted, okay, because it is unlawful assembly. Besides that, there are some restrictions mentioned in this act, whereby under section 27A, any police officer may order the persons involved in the activity to stop the activity and other people to disperse if the assembly in private premises is directed to or is intended to be participated by people outside the premise. Then the assembly is joined by 20 people or more outside the premises, the private premises. Then the assembly is likely to be prejudicial to the interest of the security of Malaysia, or simply may cause disturbance of the peace. In addition, regarding the usage of musical instrument or the flag, the flags or the banner or the placards or any devices such as loudspeaker or amplifier used in any assembly, police officer may regulate the extent to which musical to be played, or the usage of any flags or placards according to section 28 and section 30 of the Police Act.
Thank you, Ms. Aina, for the explanation. Next, we move to Mr. Ahmad Suhi. So, Mr. Ahmad Suhi, on 30 April 2021, hundreds of Malaysian youth have gathered for a sit-in protest, calling for Parliament to immediately reconvene and the end of state of emergency. Previously, although Ms. Aina have mentioned some restrictions under Police Act 1967 regarding to the issue, is there any restrictions on the freedom of assembly?
Okay, thank you for the good question, Miss Moderator Shafawatul Husna. Yes, there are some restrictions on the freedom of assembly. As we are already informed, freedom of assembly ensures people can gather and meet both publicly and privately. Assemblies can be platforms to advocate for change and for people to raise awareness about the issues that matter to them, whether it is human rights or socio-economic rights or any other issues. As with all constitutional rights, the right of assembly may be limited in some situations. including when gatherings threaten public safety and health. There are few restrictions government may impose on the right to gather. No First Amendment rights are absolute, but the right to gather is the only one that includes the most important limit, or in the actual words of the amendment, the right of the people peaceably to assemble. That means law enforcement may break up any gatherings that has turned violent or raises a clear and present dangers of violence disorder, according to case of Canwell and Connecticut. The clear and present dangers standard is a particularly high hurdle of government officials to overcome if they want to prevent planned gatherings ahead of time. Violence or the threat of violence isn't the only limit on the right of assembly. Authorities may also prevent or stop gatherings that clearly pose other immediate threats to public safety. Police routinely arrest protesters who block traffic in freeways or bridges. That's generally allowed because maintaining public safety involves keeping streets open and traffic moving. Hence, to make it short, there are some situations where a public authority can restrict your rights to freedom of assembly and association. This is only the case where the authority can show that its action is lawful, necessary, and proportionate in order to protect national security or public safety, prevent disorder or crime, protect health or morals, and protect the rights and freedoms of other people. Okay.
Thank you, Mr. Suhi, for your crystal clear explanation. There's a case that I heard which is in the case of Xiao Bingpo against public prosecutor. In this case, there are 42 lawyers who were charged for taking part in unlawful assembly. The court held that any assembly held without a permit is deemed to be unlawful assembly, and whoever attends or participates in the assembly will commit an offense. So, there is a question that has been playing in my mind. Since there are some restrictions of the liberty of assembly, is there any statute that will punish the wrongdoers, or is there any provision that you may provide regarding the restrictions stated previously?
Yes, indeed. There are some provisions provided under the Penal Code regarding this matter, including, firstly, according to Section 141 of the Penal Code, the provision stated the definition of unlawful assembly, which is an assembly of 5 or more persons, is designated an unlawful assembly if the common object of the persons composing that assembly is to overawe by criminal force or show of criminal force, legislative or executive government of Malaysia or any state or any public servant in the exercise of the lawful power of such servant to resist the execution of any law or of any legal process, and to commit any mischief or criminal trespass or other offence. Besides, it is stated under Section 151 of the Penal Code, whoever knowingly joins or continues in any assembly of 5 or more persons likely to cause a disturbance of the public peace after such assembly has been lawfully commanded to disperse shall be punished with imprisonment for a term which may extend to 6 months, or with fine, or with both.
Apart from that, the protest was held during the pandemic of COVID-19. Today, the daily cases in Malaysia reached 6,000 per day. So, what do you think the application of restriction regarding the protests during the pandemic of COVID-19?
Okay, so in an attempt to mitigate surging infection and hospitalization rates during the course of the COVID-19 pandemic, state governors, mayors, and other local public officials issued emergency orders limiting the size of public gatherings and closures or restrictions on certain businesses, including restaurants and bars. And in response to those orders, residents' business churches and other organizations filed lawsuits claiming that the restrictions violated their constitutional rights, including the right to gather. In many but not all of the cases, the lower courts denied the plaintiffs' request for injunctions to prevent enforcement of the restrictions, finding that the emergency orders met the requirements for content-neutral restrictions on the time, place, and manner of the gathering. Naturally, there have been appeals. So far, there hasn't been a definitive appellate court ruling violated the right to gather, which is the US Supreme Court ruled in late 2020 and early 2021 that two states' restrictions on attendance at religious services during the pandemic could not be enforced. But those rulings were based on freedom of religion rather than the right to gather. Okay.
That's a very quick explanation. Finally, we have come to the end of our forum this morning, where our panelists have shared a lot of information which we don't even know before. For the last word for me, I would like to thank again to all audience and also to our panels. A billion thanks I dedicate to everyone for coming to this forum. See you next time on the other topics. Thank you.